Here at Scott Legal, we know the complex issues presented by immigration law. We are here to help you navigate the oftentimes difficult road in acquiring or maintaining your immigration status. We are here to help. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. On May 10, 2021, the Department of State announced that it has relaunched the International Entrepreneur Parole Program. This video explores the International Entrepreneur Parole Program, including the history of the program, qualifications, parole length, dependents, as well as how to apply. The International Entrepreneur, or IE Parole Program, promises to help foreign entrepreneurs create and develop startup entities with high growth potential in the United States. This program could be a great fit for those who do not have their own funds to invest, or who are not nationals of a treaty country, and therefore are not eligible for an e-visa. The IE program establishes USCIS's authority to grant parole status under the International Entrepreneur Rule, or IER, to international entrepreneurs who can demonstrate that they would provide a significant public benefit to the U.S. In its 1 year of existence from 2017 to 2018, only one applicant was approved for the parole program. This is because the program was initiated in the final days of the Obama administration, but was due to be eliminated in 2018 under the Trump administration. In order to qualify for this program, entrepreneurs must demonstrate the following. 1. They must establish a U.S. startup business within 5 years of applying for parole. 2. They must own at least a 10% interest in the startup. 3. They must have a central and active role in the startup entity. This means they must be well positioned to substantially assist with the growth and success of the business. They must also receive a capital investment of at least $250,000 from qualified U.S. investors, or at least $100,000 in grants or awards from qualifying U.S. federal, state, or local government entities. Applicants who partially satisfy this funding criteria must provide additional evidence of the startup's potential for rapid growth and job creation. Applicants who are approved can be paroled into the U.S. for an initial period of up to 30 months. An additional 30 months of parole may be granted if the applicant demonstrates the following. 1. The business continues to operate. 2. The entrepreneur retains at least a 5% ownership interest and continues to play a central role in the business. And finally, 3. The business has created at least 5 qualifying jobs, received at least $500,000 in qualifying investments, government grants, or awards, or generated at least $500,000 in U.S. revenue, and has averaged 20% annual growth during the initial parole period. Parole can be revoked at any time if the company is no longer in operation, or ceases to provide significant public benefit to the U.S. Under the IE program, parole may be granted to up to 3 entrepreneurs per startup entity, in addition to their spouses and children. Entrepreneurs granted parole are eligible to work only for the startup business. Their spouses may apply for employment authorization in the United States, but their children are not eligible for such authorization based on this parole. In order to apply, the applicant must file Form I-941, Application for Entrepreneur Parole. They must also include the required fees, such as biometric services fees, and supporting documentary evidence in accordance with the form instructions. The filing fee for Form I-941 is $1,200 and the biometric services fee is $85. Filing and obtaining approval of a Form I-941 application under this rule will not, by itself, constitute a grant of parole. If your Form I-941 application is approved, you must visit a U.S. consulate abroad to obtain travel documentation, for example, a boarding foil, before appearing at a U.S. port of entry for a final parole determination. A Canadian national traveling directly from Canada to a U.S. port of entry may present an approved I-941 at the U.S. port of entry without first obtaining travel documentation. Dependents of the entrepreneur submitting Form I-941 should also file Form I-131, Application for Travel Document. This should be filed with the required application fee and biometric services fee, to request parole to a company or join the entrepreneur. Form I-131 may be filed concurrently with Form I-941, or it may be filed separately. Should the entrepreneur's spouse choose to work, they should also submit Form I-765, Application for Employment Authorization. For more information, take a look at the description below. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you. You can also schedule a consultation by clicking on the link below, where you can choose a day and time that is most convenient for you.